Can the courts and litigation save the country?
The highest courts are actually an integral part of the leading elite. Whenever you're dealing with a very profound ideological issue in any jurisdiction, you can expect that the highest courts will actually give judgments against you.
It can be a very powerful mechanism to solve concrete problems and to achieve some very constructive outcomes.
We have a large number of examples where we did, in fact, have successful litigation over the past many years.
The answer to can the courts and litigation save South Africa? The answer must be... I'm Russell Lamberti, Executive Director and Chief Economist at Sakeliga. I sat down with Professor Koos Malan, a constitutional jurist and fellow at Sakeliga. We discussed the important question of what is the role of the courts and litigation in South Africa. Can the courts and litigation save South Africa? What is the appropriate role of litigation in achieving sound economic reform? You're going to find out this and much more in a very insightful discussion. Professor Koos Malan, it's wonderful to have you in the Sakeliga studio, and we're going to answer a very important question today. Can the courts and litigation save the country? Professor Koos Malan is a constitutional jurist, a fellow at Sakeliga. He's written the book Politocracy in 2012. There is no supreme constitution. I think one of your most important contributions in 2019, as well as a constitutional law handbook with a colleague in 2022 that was released. So you are... I can't think of a better placed person to have this conversation with. So thank you so much for joining us here. We've just been through a recent period where the Constitutional Court made a decision on a very controversial political song, Kill the Boer. And that decision was extremely disappointing to many and has caused a lot of cynicism about the value of the Constitutional Court, the value of appealing to the courts and litigation. And people are saying there is no value anymore in the courts. And on the other side, we get people who say as long as there is some functionality in the court system and the adjudication of constitutional matters, the country will be okay. And these are these two extreme views. Why are both of these views wrong at present? And how do we see this differently? How do you see this differently, Prof?
Yeah, Russell, thank you for the invitation. It is good that we actually tackle this topic. It's also a very appropriate time to tackle this topic. Well, actually, it's always an appropriate time to tackle it, but especially against the backdrop of the decision of the Constitutional Court that you referred to, relating to the "Kill the Boer" chant. It's not a song. The reluctance, or rather the emphatic decision of the Constitutional Court not to entertain that appeal by AfriForum. Now, that obviously, as you've indicated, caused many people to say, well, there's no basis for having any more trust in the Constitutional Court and the courts in general, in contrast to the other view that you've also mentioned. I think the truth is actually goes both ways. Whenever you're dealing with a very profound ideological issue in any jurisdiction, not only in South Africa, but anywhere in the world, be it in the United States or Britain or Germany or wherever, whenever you deal with an ideological question, a question that goes to the very heart of the ideological commitments and aims and objectives of the governing elite, you can expect that the highest courts will actually give judgments against you. And we have quite a number of examples also in South African jurisprudence that clearly proves that to be correct. As I've said, not only in South Africa, but also in other states, in the United States specifically also. So you must expect, a litigant must expect that when he tackles such a question and goes to the court to ask for a judgment going against the ideological commitments of the governing party, you must expect that you will be a loser. because you've actually then asked the wrong question. You've actually tackled the wrong issue. In contrast to that, there are many questions. As a matter of fact, the vast majority of cases, specifically also cases of a public law, or more specifically of a constitutional nature, where you can in fact successfully approach the courts with the expectation that you will in fact be assisted by the courts. The courts will then give relief in your favor. In South Africa, we have many such examples. If you deal with a question regarding administrative dysfunction, if you deal with cases regarding corruption, if you're dealing with cases regarding state failure in general, which has a bearing upon the interest of the public largely, in other words, typical questions that have an impact upon not only the interest of a specific section of the population, but the population in general. In that case, you can expect that the court will most probably help you. And we have a large number of examples where we did, in fact, have successful litigation over the past many, many years, in spite of the fact that you have this example that you've started with of the Constitutional Court giving a disappointing judgment. But as I've said, a disappointing judgment in relation to an ideological question. There are many such cases. I also wrote on that. But don't expect, you've actually approached the court with the wrong issue in that particular case.
Yes, a disappointing judgment, but not a surprising judgment necessarily, if you understand how the courts work. So in the main then, the answer to can the courts and litigation save South Africa, the answer must be no. There's clearly a limited application.
Yes.
Valuable nonetheless, but clearly a limited application for what the courts can be used for. And this is not just a South Africa question, this is a global question.
Yeah.
Can the courts and litigation anywhere ultimately redeem a system or save a system or,
That's right.
or rectify a political system that's going in a particular direction? The answer to that must surely be no.
Absolutely so. It is very important to understand that in all systems, the highest courts are actually an integral part of the dominating or the leading elite. Yes, in constitutional law theory, more specifically constitutional law doctrine, we make a distinction between the legislature, the executive, and the judiciary. But in the final analysis, the only difference between these three arms of government are in the first instance a personnel difference. If you are a judge, obviously you can't also be a minister or be a member of the National Assembly. Yes. Firstly, and then secondly, there's a distinction as far as duties, responsibilities are concerned. But over and above that, that's a very, very important truism, which I think for a very long time has not properly been realized by the South African public broadly, which to a large extent, I would say, is also a mistake caused by very many of my colleagues, with due respect to them, that a kind of a faith has almost been inculcated into the public, that the courts are almost something like an official or an unofficial opposition of the ANC, of the government and of the executive.
And of the executive. And there's this idea that they are indeed independent from.
That's right.
But they're not. They're independent in kind of official function. But there's an official function, and then there's a kind of reality.
Well, I think there are two issues to properly emphasize in this regard. The first question relates to independence in a very, very important sense, even though in theory, in terms of doctrine, the courts are independent. In a very, very important practical sense, they are not. I mean, the fact is that the courts have no power as such. The courts only, in the best scenario, has authority. Authority that it can hope that as a result of their intellectual standing, their moral standing, it will give a judgment that will give judgments that will eventually be obeyed by the executive. Okay, if the courts are not viewed highly, and if the executive simply does not want to give effect to a court's judgment, well, then it won't be given effect to. That's the first thing.
Yes.
And secondly, as far as independence is concerned, the courts don't have a police force. The courts don't have the necessary hard power to actually give effect to its orders. In the absence of the actual assistance by the executive, the court's orders might turn out to be, it sounds cynical, but may turn out to be wishes and nothing more than that.
Yes. That's interesting, this idea of the courts actually not so much being independent, but actually dependent upon executive capability in many respects, but also on the prestige the authority vested in the court by society and by the people of society. So the court is very much dependent on these things. Let's crystallize for the viewer, what are the wrong, therefore, given what these first few minutes of the conversation, what are the wrong questions to ask of not just the Constitutional Court, but the high courts and the appeals courts? What are generally the wrong types of questions to ask in matters of litigation, and particularly public interest litigation in South Africa?
Okay, I'm going to give the answer in a little bit of a roundabout way, focusing upon two things. The first thing is this: one should understand, as I've already indicated, that by and large, the highest courts specifically are an integral part of the dominant elite. Okay? So as a result of that, courts, especially the highest courts, will never give judgments that somehow dislodge or disrupt the core ideological objectives of the governing elite.
Yes.
That's the first thing. Then secondly, the court must also look after its own institutional security. It cannot give judgments which will cause the executive and the governing party in Parliament to actually criticize the courts in a very serious way.
Or threaten
it must protect itself.
Yes.
And that brings us to the answer to your question. You cannot ask a question, that will be the wrong question, to actually give a judgment that that squarely go against the ideological assumptions and the ideological objectives of the governing elite.
Now, someone might say to you, but hang on, were there not judgments in the highest courts that went against the state president, Jacob Zuma?
Yes.
Does that not disprove this notion? Are they not, in fact, in that instance, showing their independence and going against the executive authority?
I'm very glad that you actually answered the question, because that's a general misconception. The answer is no. I might mention two questions in this regard. There was the Nkandla case already 7, 9, 10 years ago. The Nkandla case dealt with the corruption of Mr. Zuma and the corruption of a particular section within the African National Congress. But at the same time, that judgments, the Nkandla judgments, also served the purposes of, at that stage, an emerging front within the African National Congress, which eventually in 2017 proved to be successful within the ANC, and which culminated into the election of Ramaphosa. So no, it didn't have anything to do with the fundamental ideological assumptions, nothing to do with transformation. On the contrary, that judgment, as good a judgment as it was, and it was a good judgment because it squarely went against corruption, but at the same time it actually restored the imbalance that at that stage was prevalent within the ANC, and gave it the opportunity to, with greater strength, proceed with its ideological path.
So in a sense, it was an adjudication of an intra-executive or an intra-ruling elite dispute.
Exactly.
It wasn't something that was going against the executive per se. So in other words, these heavily ideologically laden questions, these are going to be questions that you're going to struggle to have success with in the courts. And one of the foundational ideologies of the present regime, as it were, is transformationism.
That's right.
And you get some people who suggest, but you should take BEE should be put before the court as unconstitutional, as fundamentally unconstitutional, and we should strike the BEE Act of 2003.
Yeah.
That should be struck down, and it could be struck down in the Constitutional Court. Tell the viewer why that's wishful thinking.
Well, in the first instance, let me just put on record that I view BEE for a variety of reasons as something that should in fact not command the support of any of us. It does not promote equality. It does not promote the black people in general. So it's not a question of triple BEE, of broad-based black economic empowerment. But we're dealing with a question that goes to the very core, and which is actually a manifestation of the very core of the ANC's ideological objectives. So precisely for that reason, you cannot take that kind of case to court. One can predict for sure that you will definitely fail. But what you can do, and that's the very important thing, you can tackle definitely questions relating to BEE, which deals, for example, with decisions that were taken by, say, the Department of Trade and Industry or any other Department of Agriculture also, which is ultra-virus. In other words, that went beyond the power that vested in the particular in the minister or in the Director General. You can question that. Yes. And the chances are good that you will in fact succeed with that, because in that case, what you confront the court with and what you ask the court to do is to rule, strictly speaking, on a technical question that the relevant functionary went beyond its own powers. Yes. You can also there's also a lot of corruption involved in that particular framework. You can almost tackle any questions relating to corruption within the BEE framework without tackling the basis of BEE and without actually calling BEE by name.
Yeah.
Because the moment you're going to call it by name, you run into rhetorical troubles, which is going to cost you a problem as far as that litigation is concerned.
So we've dealt with the kinds of questions not to ask the courts. And you've started alluding to the kinds of questions that we should be asking the courts if we want to get constructive outcomes. And if some of the questions not to ask the courts are questions that are laden with ideology and that strike at the heart of executive authority and power and so on, if those are difficult questions, the easier questions and the questions likely to have more success would be more concrete questions, questions that address and potentially propose solutions for concrete problems, or things, as you've said, that might be slightly peripheral to that core ideological issue, that nonetheless the court, but because it's peripheral to it, the court feels far more at ease to make sound judgments around these things, like a minister who enforces BEE but does so outside of his constitutional or legislative powers. And the court will say, we're not actually saying that the BEE part was wrong, we're saying that you acted outside of your powers. Yeah. And so this adjudication of constitutional limits, perhaps process issues, which are quite concrete.
Very important, yeah.
And so would you agree that these are the sorts of questions, concrete questions around process, powers, and adjudicating the kind of limitations of where the executive and other state entities, how they can act, how they can resolve disputes amongst one another, and so on. Very, very concrete sorts of questions.
Exactly. One mustn't place the courts in some kind of a quandary where it has to make a decision on the ideological plausibility of BEE, of transformationism, of the so-called National Democratic Revolution. Those terms should actually never feature in litigation, the kind of litigation that, say, for example, Sakeliga is involved. But questions relating to corruption, which is very specific, which relates to malfeasance, in other words, of a particular executive functionary. Yeah. Questions that relate also very important to the interest of a specific person, a specific person that was caused harm. Questions that relate to the public in general, not only business people, also business people, but perhaps generally causing harm to the public. If you can, for example, if I may quickly mention this question, the national health insurance is a very important ideological thing for government. But you can actually divorce that socialist idea from how is this thing going to function. So you can introduce a wide variety of very specific questions that will eventually challenge the court and actually allow the court, I shouldn't say challenge, that actually enable it to pass judgment on the interests of the public.
Yes.
The public, the poor public, one can even say, or the specific individual medical practitioner or nurse or whatever, or the specific hospital. In other words, where you have flesh and blood kind of interests, courts are very well placed to give judgment on that, which they can do without in any way going into the ideological intricacies of what what might be the background of that.
So we've spoken about the kinds of questions that could be asked of the court, and then there's different kinds of judgments, in my understanding, that a court might give, and those judgments, for example, could require that the executive branch does something or implements something. They must now do something. But then you get the kinds of judgments that require the executive to refrain from doing something, or in the same breath, enable non-state actors like businesses or various organizations to lets them know that they now no longer have to do something. It's the latter kinds of judgments that in general, and there will be some exceptions to this, but in general it seems to me would carry far more weight and have far higher probability of having effect. Whereas when you require the executive authority, who really has power, to do something, particularly in a South African context, sometimes that just doesn't happen. If you require, you couldn't, for example, require a parastatal like Eskom to produce more power, but also you couldn't necessarily require the police to make certain arrests. I mean, courts do indeed try and order the police to do something, but they may not do it. And the courts seem to have very little ability to push that through. So it seems that the kinds of judgments, not only asking the right questions, but in asking those questions, to seek the kinds of judgments that, in a sense, are what we might call negative judgments, to tell the state or non-state actors that they now may refrain from doing something. And those seem to carry a lot of weight. Because court judgments in a society that we have, that's still where courts and the legal sphere has prestige and is held in high esteem, good judgments like that can really grip a business community, for example, and it redefines ethical lines quite strongly. If you get a good judgment and businesses now realize they no longer have to do something, from the very next day, that will be how they will start to essentially implement that if it's a good judgment. And that's where you get kind of quite powerful judgments out the court.
Actually, there's a beautiful constitutional doctrine, also not only a constitutional doctrine, but a law of procedure doctrine called the doctrine of effectiveness. Courts will not engage and should not be engaging in matters where their orders will not be effective. There are many examples where courts have refrained from tackling cases, from giving judgment in cases where the judgment or the so-called order will not be given effect to, and where there can, in other words, not be given effect to the doctrine of effectiveness. This clearly brings forward what you have said now, that if a court if the court gives an order requiring the state to refrain from doing something, obviously it's easy for the executive to refrain from something because he can just sit back and do nothing. And without being sarcastic, this is actually something that nicely fits into the present South African situation, because we have a very ineffective executive.
Yes.
We have an executive which might be effective when it comes to doing bad things, producing bad policies, and eventually actually acting to the detriment of the public in general.
Yes.
So, in other words, if a court can give a judgment that says that requires the state not to do anything, to refrain from doing, that would also satisfy the doctrine of effectiveness, and would also, to repeat, sorry for that, would fit into the present lethargic state,
Yes.
to put it mildly, of the executive.
But on the other side of that, in the same breath, that judgment gives companies
Yes.
the ethical,
leeway,
the leeway
freedom.
and the ethical authority and freedom
Yeah.
to not comply any longer with that which they were being forced to comply with. So even if the state tries to start disobeying that court order and they try to continue doing what they were doing, they face a business environment, for example, if it's a business issue or an economic issue, that simply has been empowered by this authoritative judgment, decision, to not comply.
Yep.
And they do so with a clear conscience.
Yeah.
And so it becomes extremely difficult for the state to even continue doing that thing if they wanted to.
Yeah. Also, once you have stopped, once the state have stopped doing something, it's actually very difficult to get into action again.
Indeed.
I might just add the following, which I think in the present climate is getting more and more important, and that is that as the legitimacy to a large extent of the state is diminishing, owing to its ineffectiveness also to comply with certain very, very basic rights in terms of its own ideological assumptions, such as socioeconomic rights, regarding, say, supply of water,
housing,
supply of electricity, housing, health, and so on. This is happening on the one hand. On the other hand, you see a private sector that is actually getting stronger and stronger, more potent by the day in two respects. Firstly, in that the private sector clearly has much more know-how and much more abilities, many more abilities than government actually has, which is completely the opposite of what, in terms of transformationism, the African National Congress would like to see. But that's the first thing. So the private sector has the ability to do many more things than previously it was thought possible. And the important thing also, which is the next thing I want to mention, is that I think that there's also a strong possibility that the public's trust and the public faith generally in the private sector is actually rising, precisely because the private sector is proving more and more to be a factor that the public in general, the most poor people, can actually have trust in. And I think in one's litigation, litigation approach, that should actually also be an important factor where the private sector, where companies and so on, where businesses and institutions such as Sakeliga should come forward as institutions that provide solutions, not only solutions to itself, not only creating liberty, leeway, freedom for businesses, but at the same time using that not only to their own benefit, but to the benefit of the South African public largely. I think that is actually a very important factor that should play an increasing role. In other words, you fit into the general human rights discourse, actually arguing that the private sector is much better suited as a result of the fact that it has more abilities than government itself to make to give effect to a variety of also specifically socioeconomic rights of the public.
So let's sum up. The courts by themselves and litigation by itself cannot save a country. It cannot change an order per se, but it can help. It can be a very powerful mechanism to solve concrete problems and to achieve some very constructive outcomes. Some of those are relief. For example, when Eskom was cutting off towns because municipalities weren't paying their bills, Sakeliga intervened along with others, and we were able to help resolve that so that businesses no longer got cut off unfairly, and that dispute had to take place between Eskom and the relevant municipality.
Yeah.
And so there was tremendous real-world business relief in that concrete case. So there's solving concrete problems. Our litigation in Lichtenburg in the northwest is looking to address and solve very concrete problems of a failing municipality that affects real people's lives. And we've had judgments there where the judges have chastised our opponents by saying, why are you opposing this case? This is trying to deliver water to people. This is trying to fix infrastructure. Potentially to shift certain ethical considerations. For example, Sakeliga is taking on what we call the third wave of BEE. Now, BEE itself is a very legally and kind of ethically embedded ideology. The ideology of transformationism is embedded in mainstream corporate life in South Africa. But what we call the tentacles of BEE, as they start to grow out, and we're trying to chop those tentacles off in our third wave BEE litigation. And as we're doing that, and as we get good judgments on that, and as we show people that the state actually may not do these things, we start to embolden a re-emergence of a different ethical order. As people start to say, yes, indeed, and then the court validates that, yes, this is in fact outside of their powers, and this is wrong. And so you're reshaping those ethical considerations. And then the other one I see is it's the stopping the outgrowth of new harmful regulations. So a lot of what's embedded already in legislation and so on is very difficult to overturn. But the outgrowth of regulation from regulatory bodies that are in many ways taking a chance that these things haven't been established through parliamentary processes, regulators are trying to do more, or new legislation that is harmful, that is perhaps irrational, that has not followed due process properly, and all these kinds of things. And what this does is it can frustrate the executive in trying to enact harmful policies and trying to extract value from the economy. It can frustrate them. It can buy time. It can create freedoms and scope for businesses to grow and create value. I've said a lot there, but perhaps you want the last word.
Yes.
How would you like to add to that or qualify what I've said, that this is what we can achieve? And actually, it's not the ultimate solution. It's not something that we should rely on as the only mechanism.
But it's certainly meaningful.
But it's a meaningful mechanism. So have the last word on that mechanism.
I think there are three last observations that I would like to make. I hope I can remember all three of them. In the first place, I think it's very important for the private sector, for private business, to actually realize what its own abilities are and to tackle these questions in a variety of ways. Well, obviously also through autonomous action and so on, which is not a topic of this conversation, but also through litigation. I think one will find that, and one does find increasingly, that if you ask questions that will eventually allow the courts to give judgments which is to the benefit of that specific company or that specific organization such as Sakeliga, but at the same time also to the benefit of the public in general, you're going to get good judgments. That's the first thing. The second thing is, and I think the second and the third is now combined, is this. You mentioned the ethical question, and that's very important. In the last many decades already, but especially since the ANC has come to power, the state and state action is regarded as by definition somehow ethical, as if the state is capable of some kind of salvation.
Yes.
Well, precisely the opposite has overwhelmingly been proven as a result of the fact that to the extent that there is help, I won't say salvation, that takes it too far, but it can much better be provided by the private sector. But to that end, the private sector must have the leeway. It must have the ability to act. It must get the state off its back. And I think that is also something which is becoming part of the general discourse. We have had the whole Zondo Commission reports and so on. So it is a notorious fact already at this stage, also very well known to the courts themselves, that the state is in fact not this so-called effective and ethical solution to our problems, thus giving that leeway, that possibility, that freedom to the private sector. A private sector then that must actually, just to strengthen that ethical question, that must come strongly to the fore. And I think the private sector is well placed to do it, well positioned to do it, in terms of an argument, but also in terms of its abilities, because it can make true what it promises. And what it promises and what it wants to make true is to create more space for itself, but at the same time, and that should be combined as far as I'm concerned also in litigation, to involve the interest of the public in general, as a result of which all litigation, or much of the litigation in which the private sector is involved to fend off illegitimate encroachment of the state, is simultaneously acting to the benefit of the public generally, as a result of which all litigation, or the vast bulk of litigation in which the private sector is involved, it's actually public interest litigation, because it serves the public interest in general, which, by the way, as you would know better than I do, is also an integral part of the objectives and the philosophy of Sakeliga.
Professor Koos Malan, thank you so much for joining me. That was fantastic.
It's my pleasure. Thank you.
A quick message. We share conversations like this one on a regular basis, and if you're currently unsubscribed, please consider subscribing. Now at Sakeliga, our mission is clear. We're working to shape a flourishing business environment, unburdened by harmful economic policy, and one that's resistant to state failure. There's an immense amount of work ahead, and your support makes it possible.